judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral argument at the 5th District Court of Appeal. I've already been introduced. Let me introduce the other panel members. Seated to my right and your left is Judge Jamie Grosshands, and then to my left and your right is our newest member of our court, Judge Meredith Sasso. We have 3 cases scheduled for oral argument today, 1 criminal and 2 civil. In each case, and this has been a change, criminal case, we're now giving each side 20 minutes, the same as civil. When the appellant comes up here, if you let me know how much time you wish to save for rebuttal, I'll try to help you in keeping your time. If you have a cell phone or any other electronic device, make sure it's turned to the silent mode or turn it off so that the oral arguments are not interrupted. We'll be taking a break after our second oral argument. If any attorneys wish to join us in the attorney's lounge, we'll take a few minutes to join you there. And that, like I said, that'll be after the second case. So we'll go ahead and start with the case of Tucker versus State.
May it please the court. My name is Camille Shepard, and I'm here on behalf of the appellant, Mr. Clayton Tucker. May I please reserve 8 minutes for rebuttal?
Okay, you may proceed.
We are here before this court on an appeal of the denial of Mr. Tucker's Rule 3850 motion following an evidentiary hearing. In Mr. Tucker's motion, he alleged numerous claims of ineffective assistance of counsel. However, due to time restraints, I will focus on the ones that merit the most discussion while not waiving any of the other grounds alleged in the motion. I will address the facts as they pertain to each ground. However, running throughout the entire case, a pertinent fact to each ground is the fact that this is a credibility contest. It's a he said, she said. There was absolutely no physical evidence of any sexual contact. There are no eyewitnesses to the crime. This fact is especially relevant as it relates to the prejudice prong of Strickland. As this court and courts throughout Florida have found, when there's a credibility contest, anything can sway the jury. In turning to Mr. Tucker's first ground, Mr. Tucker alleged ineffective assistance of counsel for failing to call 2 key witnesses. These 2 witnesses, you can call them medical witnesses. Nurse Susan Gorey was a sexual assault nurse who was supposed to collect physical evidence. She conducted a 2 to 3 hour examination on the victim.
Now, counsel, can you just tell us why you think that particular testimony would have been effective? Because it's my understanding several days had passed between the alleged assault and the examination, and she testified that there would not necessarily have been any evidence there. So why was that not just a strategic move by defense counsel?
I think it's important to note several things about Nurse Gorey's testimony that there would be no physical evidence. It was not in Nurse Gorey's realm of expertise to interpret the evidence. Her sole job was to collect the evidence and document it. When she testified at the evidentiary hearing that you wouldn't necessarily expect any physical evidence, she was testifying only as it related to the hymen and whether or not a rupture indicates sexual activity. That opinion came from a book that she read prior to the hearing, so it's inadmissible opinion testimony to begin with. I think it's worth noting the common sense argument, why would you subject a 14-year-old minor child girl to a 2 to 3 hour exam if you did not expect to find evidence?
But the defense theory was that the victim was making up the story because she was having sexual relations with a boyfriend, and her mother was going to find out, and so instead she blamed the defendant. So how would that evidence have assisted the theory of defense?
And I think you first have to look to trial court's contention that it was his strategy to show that after numerous denials, the victim changed her testimony. Throughout the record, trial counsel did not employ this strategy. If you look at ground 4...
Well, he got out that she changed her mind on the way to the doctor's office while her mother was driving her there, right?
That's correct, but there was absolutely no testimony or evidence to indicate why she would be nervous about a sexual assault exam. The mother testified during trial that she was not worried about any sexual activity of the minor child. The only thing that she was worried about was whether or not the victim was having sexual intercourse with Mr. Tucker. She wasn't concerned if she had a boyfriend and was having sexual intercourse with him. And that was her trial testimony, which was damaging to Mr. Tucker.
Would you agree that in most of these cases where you have a sex abuse, alleged sex abuse victim, and they're saying that, you know, the defendant sexually abused them, that it's not unusual for the defense attorney to try to come up as a theory with a motivation, because why is this person lying, if you would, to get the defendant incarcerated, you know, going through trial, going through examination, et cetera. You know, normally most defense attorneys want to be able to try to explain something to the jury. You know, this is revenge, this is vindictiveness, this is to hide the fact they're having sex with a boyfriend, whatever it is.
I would
My
absolutely...
experience is that most defense attorneys try to come up with some basis to explain why the victim might be lying.
I would absolutely agree, but it's worth noting that trial counsel didn't actually employ the strategy. Obviously, that's a great question to try to answer why the victim would lie, but I don't think the evidence supports that the trial counsel actually did this. We just had a Super Bowl on Sunday. I'm sure it was both teams' strategy to win the game, but you have to take steps to employ that strategy. It's not just, I want to win or I want to explain this.
Well, how did trial counsel not employ that strategy when it was the focus of whether or not to call the witnesses? It was the focus in calling the mother to the stand. It was the focus on the cross-examination of the victim. It was the focus in closing argument. How does that not constitute a strategy?
The victim was never asked on cross-examination about any prior sexual contact, so it was never brought up in that context. As it relates to calling Mr. Tucker himself, trial counsel testified that he needed to call him to answer the question of why the victim would change her story. However, this evidence never came out into the trial of why she would lie and why she would be nervous of a sexual assault exam. And in fact, the state seized on this fact in their closing arguments. They said there's absolutely not a shred of evidence that was presented as to why the victim would be nervous about a sexual assault exam, and there's absolutely no evidence of any prior sexual activity at all. And in calling Mr. Tucker, as he alleges in the fourth ground of his motion, not only did he fail to get the evidence, the reason why he called Tucker out at trial, he also completely failed to prepare him to testify.
Now, the state has argued in their brief that the time he had to look at the transcript was sufficient.
Your Honor,
why do you think that that's incorrect?
Your Honor, he had less than 2 hours to look at this massive transcript. It's undisputed that during the time that he was supposedly going over this statement with his trial counsel had not prepared for jury instructions, so he was working on jury instructions. This statement, Mr. Tucker needed the guiding hand of counsel to review this statement, go over it. Because he was not provided the statement and his trial counsel did not go over it with him, he was impeached no less than 8 times on the stand.
Let me ask you this. Was there any evidence as to what his testimony would have been if he had been properly prepared?
I think that his testimony The biggest,
Well, at the evidentiary hearing on the motion for post-conviction relief, did anyone present evidence that if he had been properly prepared, this is the evidence that would have come in instead of the evidence that actually came in?
I don't think that it's the evidence that would have come in. I think that had he been properly prepared, he would have avoided being impeached 8 times.
Well, how can we determine prejudice if we don't know what would have been the result if he had been properly prepared?
And I think it comes to the fact that without these impeachments, the state couldn't have seized on their closing arguments when they said, Tucker's lying, Tucker is attempting to conceal these things.
Was he impeached on anything substantive?
He was. He was impeached on, while the state might try to claim it was insignificant, there were impeachments that directly related to the victim, including whether or not he had referred to her as his girlfriend, whether or not he made up a nickname for her. They all directly related to the victim.
But he had said many of those things in his original statement to the police, which was coming into evidence.
Yes, Your Honor, he did, and that's undisputed. However,
So defense counsel was stuck with that statement.
yes, defense counsel was, yes, Your Honor, he was absolutely stuck with that statement, but without these impeachments, the state couldn't have argued Tucker's lying. He's attempting to conceal things. It might appear minor, and yes, it was already in the statement, but allowing those impeachments opened the door for these closing arguments, and also common sense, the jury's sitting there hearing these impeachments. Well, if he's lying about something small, what else is he lying about? And I think it totally opens the door that wouldn't have been opened had he been prepared. Similarly, he also, while trial counsel allowed Mr. Tucker to be impeached numerous times, he missed key opportunities to impeach the alleged victim. For example, the victim's mother had testified in her deposition that Mr. Tucker was in no way in charge of the victim. He had no authority over the victim. The victim herself had testified that Mr. Tucker was just around the house, had no authority. In her deposition at trial, she asserted, he was like a father figure to me, he could punish me, he was in charge of me. In a credibility contest where anything can sway the jury, this fact becomes key.
Let me ask you, what was the maximum sentence that Mr. Tucker was facing if the jury had not found familial custody but had otherwise convicted him?
Your Honor, I can answer that question with certainty. I do not believe it was life. It was a lesser sentence, I believe in the 40-year range, but I will confirm that fact because I'm not absolutely certain.
So, if I recall correctly, Mr. Tucker was 47 at the time of trial, so a 30, 40-year sentence might, well, as a practical matter, be a life sentence.
Yes, Your Honor, I think the custodial and familial relationship is not the strongest ground. I think it becomes important with the impeachment, and it becomes important in the cumulative error. In ground 10, Mr. Tucker alleged a cumulative error. Trial counsel failed to call 2 key witnesses who would have undercut the victim's account. He didn't prepare his client to testify using his lengthy statement, which allowed him to be impeached on cross. He doesn't get the evidence out that he wanted to from Tucker about why the victim would suddenly change her story. He calls the victim's mother when it was totally unnecessary, as her testimony was cumulative and allowed her to bolster the victim's credibility. And he failed to impeach the victim on the familial and custodial relationship. It's essentially death by 1,000 cuts, and that's why there is this cumulative error doctrine. So if you don't find one deficient performance, you can find them all together to be prejudicial to Mr. Tucker.
You're a little over 7 minutes. So, okay.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. First of all, let me dispel the notion that this was a he said, she said case with no corroboration. We have a lot of Facebook messages and things like that in this case. This is how it all came to light, is the victim's dad was in Korea and saw these posts on Facebook and contacted DCF for the investigation. That's how the allegations came to light. The defendant posted pictures of the victim lying on the couch and said, "sexy girl," as his comment. She's a 14-year-old girl. He's a 47-year-old man when this happened. He called her by the nickname Boobs. He said that to the police. He admitted that he said, if a girl is old enough to bleed, she's old enough to breed. He admitted to the police that she would wear short shorts and he would tell her to bend over. There's a Facebook Messenger conversation that was put into evidence where the defendant was messaging the victim saying, "Hey, hottie, hey, cutie pie, good night, sweetie." The victim said, "Please leave me alone, I'm at the movies." And the defendant said, "Are you making out with your new boyfriend?" And the victim said, "Yeah." And he said, "I'm so jealous." There's a lot of stuff in here beyond the he said, she said. As far as the physical evidence here, the defense strategy was that the victim freaked out in the parking lot when she was going to be examined because she didn't want her mom to know that she was sexually active. That was the strategy. So that fact that, you know, her hymen was intact, that doesn't help the defense. It doesn't hurt the defense, doesn't hurt the state, because if you've done these cases for a long time, everybody knows that that doesn't mean that the child hasn't been abused. That's something that's very easy to disprove as far as the state goes. Even if this particular nurse couldn't have testified to that, if they had put the nurse on and said, "See, no injuries," it would have been pretty easy for the state to have a rebuttal witness who could testify, "Look, there's no injuries, that's a very pliable tissue, and we don't expect to find injuries." It was 3 days later. Why do they put the kids through that? That's an interesting question. I imagine they do that because otherwise the defense could argue, gee, she wasn't even examined, so we don't know what the evidence would be. We don't expect to find evidence 3 days after an abuse.
I'm going to ask you about the preparation that the attorney gave for the time that Mr. Tucker was on the stand.
Okay.
The state has argued that that was sufficient. The statement was 153 pages, and he had an hour and a half to read it. How do you think, and without evidently any discussion with his counsel during that time, because counsel was working on jury instructions, how do you think that that is sufficient to prepare someone when they're facing a life sentence to go on the stand?
Well, first of all, that's speculation, because the defendant said he didn't prepare me, but then he said, first he said, "I never saw my statement." Then he said, "Well, okay, I saw the statement during lunch hour." Counsel says he did prepare him. They didn't follow through on that with a bunch of other testimony, but during the evidentiary hearing, counsel did summarily say, "Yes, I prepared him to testify." But he clearly had his statement. When you look at the direct examination of the defendant, you know, it was decent. He said, "I didn't do this. Yes, I teased her. We just had that kind of a relationship. It was a jokey kind of thing." That's how he tried to explain all of this stuff that makes him look creepy at the very least. So he testified well, and then on cross-examination, he lost it. His cross-examination did not go well, but it wasn't because he was impeached with substantive things. He never admitted he did anything wrong. When they impeached him with the statements, it was little things like, "Didn't you tell the police that sometimes you would crawl into bed with the kids when you'd get home from work?" And he said, "I don't remember saying that." And they'd show him the statement. He was like, "Yeah, I mean, this was years ago." So he was impeached on little details that he said in his statement, but nothing significant. He admitted all that stuff. He had to. It was true. So there was really, you know, nothing indicated on this record how his testimony would have changed with different preparation. He didn't say anything incriminating except for the stuff he'd already said to the police officers, and they're stuck with that. You can't take that away no matter how much you prepare the guy. I'm sure counsel didn't want him to look coached. That wouldn't have been good either. When he was up there, he decided to do a creepy old man impression that the trial court found very incriminating.
Wasn't that also a preparation issue, though? It wouldn't
Well, he did that in his statement, though, too. So he said that in his statement to police when he was talking to him. He said, you know, I'd tease the kids and I'd be a creepy old man. And he started demonstrating apparently how that went, which, you know, on a cold record is a little incriminating. I imagine in person would be much more incriminating. So it would have come out regardless. Again, the defense is stuck with that statement. I mean, he said it to the police. I don't know how you get around that. You can prepare him for days. You still have that impression that he gave to the police that the prosecution can ask about. And what's he going to say? I didn't say that. I mean, it's all on a transcript. So there's no indication how his testimony would have changed. So with days and days of preparation, the trial court found, look, you know, counsel was with him a lot more than he says. That's always a debate at these 3850 hearings.
Well,
The defendant,
just to clarify, the attorney said that he went 3 or 4 times and spent 15 to 30 minutes each time, I believe.
I thought that's
So
what the defendant
I believe
said.
that was the testimony. So at most, 2 hours meeting with someone in preparation for
Well,
this type of case.
that's just the meeting, though. I mean, he also went through everything. He talked to the witnesses. You know, this guy came in a little bit late. He had a public defender, I believe, initially. He had a different attorney initially. But, you know, they went through the strategy from the beginning. This was not an inexperienced attorney. He had done these child sex cases before, and from the beginning, their strategy was, you have to explain why a 14-year-old that you've always gotten along with suddenly is making up these charges. And as Judge Evander pointed out, that's often the strategy in these cases, because you have to explain why the kid would put themselves through this. The kid in this case lost her family. You know, there was a big split in the family. You have to explain why that would happen. Here, they had a bunch of denials. So that was very helpful evidence, and that all came out at trial. This kid denied it when DCF first came. She stayed in the house. She denied it when the sheriffs came. She disclosed for the first time when the mom said, I'm taking you to the doctor. And she explained at trial that she disclosed that for the first time because she figured the truth was going to come out. The kid doesn't know that, you know, physical evidence isn't necessarily going to be there. She's 14. She doesn't know that. She thinks, uh-oh, it's all going to come out. I'm just going to tell the truth. Why they didn't get further evidence that she made it up to cover sexual activity? Perhaps because she didn't make it up. You can't conjure evidence out of thin air. The kid told the truth. So you can't find, you know, why she lied. But they certainly put it out there for the jury and argued she was lying. They said, you know, she had all these opportunities to tell what was going on, and she didn't take them. She was, you know, didn't want people to find out she was being sexually active. In the deposition, the victim's mom said, I was suspected she was sexually active. That's what she said in the deposition. At trial, she said, I only suspected it with the defendant. I didn't suspect it with anybody else. The defense counsel doesn't know she's going to change her testimony at trial. And he impeached her with that statement. So he called her to get that story. He called that the triggering event. And the question at this point in the proceedings is, was that a reasonable trial strategy? Or was it so unreasonable that he was not functioning as counsel? And we would submit the trial court correctly found that he was functioning as counsel. It is a reasonable strategy. It didn't go fabulously. You can't fight the truth. You can't conjure up evidence that's not there. The defendant had his statement. He denied this. The jury got to see him. He said some really bad things to the police during his interview. Of course that's going to come out. You can't prevent that. And so, you know, they wrestled with that on cross-examination. That's going to happen no matter how much you prepare a witness. And he said, I don't remember these little details, and he'd admit the ones that he did remember. I mean, The worst thing that happened on that was his creepy old man impression. And I don't know how you stop that when you've already given that impression to the police. So we would submit the physical evidence would not have made a difference. And let me reiterate that counsel, in closing argument, said there's no physical evidence here. He got to argue that, and the state hadn't put on a witness that says we wouldn't expect physical evidence because they didn't call these witnesses. If they had called the nurse, the state could have put that evidence on. That would have been worse for him. And it wouldn't have fit with their theory that this kid was sexually active and she didn't want her mom to find out. So that was the theory. They did their best they could with that. But, you know, the bottom line, if the kid was telling the truth, there's only so much you can do. The jury found the kid was telling the truth, and that's not something that we can second guess on appeal. So we would submit that trial counsel was not ineffective, and even if there were things in hindsight they could have done differently, which there always are, there's certainly no prejudice here. The result of the proceeding would not have been different based on these errors, if there were errors, and we would submit counsel performed reasonably.
All right.
Thank you.
Thank you.
It's important to note as it relates to ground one, while the sexual assault nurse, the testimony is that you wouldn't expect to find evidence 3 days later. I think it's important to think about the victim's testimony as it relates to the sexual intercourse that happened 3 days prior. Obviously, this isn't an uncomfortable topic, but she described the sexual intercourse lasting several minutes. She said it was razor sharp, it was cutting, painful. Not only was there no evidence as it relates to the hymen rupture, there were no bruises, no scratches, no tearing. There was absolutely no evidence of any sort of sexual contact on her body at all. That was examined for 2 to 3 hours.
Wasn't it a reasonable trial strategy to highlight that fact in closing without offering a witness that would have been able to explain maybe why there wasn't physical evidence?
Exactly.
3 days
So
after?
the state credits the fact that trial counsel used it in his closing argument. However, there was absolutely no evidence presented that there's an actual lack of physical evidence. Cited in our reply brief is the recent case of McBride versus State. In that case, trial counsel highlighted a fact in closing. It was a lack of school records. There were no school records and evidence, and he pointed it out in closing. And the first district found that that was ineffective assistance of counsel. He could have used the records in trial, but just merely bringing out that fact in close was not enough. And as it relates to the DNA evidence, there's absolutely no testimony anywhere in the record that you would expect DNA evidence to be gone. Numerous items were collected. Her underwear was collected. She was swabbed all over her body. There was absolutely no DNA evidence, and there's no evidence in the record that you would expect that DNA evidence to be gone. As it relates to the creepy old man impersonation, the trial court found that there was no way to stop that impromptu impersonation. However, it's important to note it was in his prior statement. Obviously, the state was going to seize on this in cross-examination. However, that's why you need the guiding hand of counsel. You give him the statement, you look it over. Presumably, I don't know if trial counsel did that, but you prepare the witness how to deal with that. Yes, I used to do these impressions, but it doesn't mean you need to get up there and do it. The state didn't ask him, can you do the impersonation? That's exactly why you need counsel to prepare you to handle these questions. Also, the state pointed out that talking to the witness, he did a lot to prepare. Well, he failed to prepare the most important witness to testify, and that's Mr. Tucker, the defendant himself. The state also argues that all of the impeachments were on minor matters, but then at the same time, they want to claim that this is substantive evidence of a sexual assault. I do think it should be noted that a Facebook message is not the same as sexual intercourse with a minor child. While the messages might appear creepy, had he just admitted they were there along with the girlfriend statement, he could have provided an explanation instead of getting impeached and pointed out that he wasn't necessarily being truthful, and that's why he needed to read the statement prior to his testimony. I also think it's important to note that the strategy becomes unreasonable when you don't implore it. He called Mr. Tucker to the stand to testify as to why anyone would suspect sexual activity. However, this does not come out in evidence at all. He calls the mother to testify that when they got to the clinic, that's when she revealed it. However, that evidence had already come out through the victim. Calling the mother allowed her to bolster the victim's credibility, all of which the state seized upon in their closing arguments and highlighted throughout. Also, as it relates to the preparing to testify, it seems like day one of trial practice, you're told you do not call a witness without giving them their prior statements. But also included in preparation of witnesses, especially a defendant, you discuss the advantages and disadvantages of testimony. You go through cross-examination to figure out what are the weak points. Mr. Tucker's testimony fell apart solely because of his prior statements and the impeachments. It goes back and forth. The state wants to go back and forth about whether or not it was substantive evidence. On the one hand, it's evidence that he did conduct the sexual assault. On the other hand, it's just minor and it doesn't affect the overall trial. But as I said before, I think this is a credibility contest. The state conceded, trial counsel conceded it was a credibility contest. In page 14 of the state's brief, as it stood, defense counsel was left with a he said, she said. Now, today, it's not a credibility contest, but at the end of the day, the only evidence as it relates to the sexual intercourse that was admitted into trial is Mr. Tucker's testimony and the victim's. Failing to call those two key witnesses allowed the victim's testimony to go. Those two witnesses would have provided testimony that undercut the victim's story. Together, all of these errors in trial counsel resulted in prejudice to Mr. Tucker. For all the reasons stated herein and in the motion, the trial court's order should be reversed.
All right, thank you. Thank you both.